you're going to see my sort of thumbnails on the left as we go. All right, so yeah, I'll skip this. I'm an attorney. I also co-founded a software company in Los Angeles a number of years ago, which is what got me really interested in software, and that's why I focus on this area now. What we're going to cover today is what I thought we'd do is walk through the legal issues that are relevant to mobile app developers in sort of sequential order. So we're going to take them not just sort of as isolated areas of law and sort of understand the law. I'm actually going to take these in the order that they generally are going to be of interest to you or of importance to you as you're going from the idea to actually a published app in the marketplace with people using it. So in brief, what we're going to talk about is making the app, like literally how you make it. Talk about publishing the app, which means basically presenting it in a way that will pass the screening process with Google and Apple, which are obviously the main app stores. There's some other smaller ones, but we're just not going to spend time on those because very few people are frankly using them. We're going to talk about commercializing the app. So commercializing meaning getting it to people to use. A number of years ago, a lot of people were charging fees for downloads. A number of years ago, we sort of crossed the tipping point where most apps were either free to use or free to download, but there'd be microtransactions or paid transactions depending on how you use them. So whether you're giving an app away for free or whether you're selling it, there are still legal issues you want to understand as you do that. So we'll talk about privacy, we'll talk about your end user license agreements, advertising laws, and a few other odds and ends like insurance, which is important. All right, as we go, if you have questions, feel free to ask. There is both a Q&A feature built into what you should see in your interface for Zoom, as well as a chat function. Sometimes I think people are not able to use the Q&A for some reason, so feel free to use either. On a second screen, I'm sort of keeping an eye on the Q&As. If I see any, I'll just sort of address them as we go. You don't have to wait till the end. Depending on what you ask, I may actually say, hold on, let me table that, I'll come back to that later. But feel free to ask as we go. I'd rather clarify things as we go. If Q&A doesn't work, ask a question in the chat and hopefully I'll see it there. And if you have more questions afterwards, you can always email me. In the deck, you'll see my email address. All right, with that, let's begin. This is going to be a little bit of a whirlwind. Rather than go into any one particular siloed issue in a lot of detail, I usually try to go somewhat in a lighter fashion over a larger number of issues. Because my thinking is that, in a presentation like this, it's not like we can sort of tell you everything you need to know about a particular silo anyway, so let's not try to do that. Rather, give you enough information about a large area of topics so you know when you actually need to look into it further as you go. A lot of this is stuff that won't become relevant to you until you've actually published your app. If you're someone who is preparing an app for publication soon, that's fine. Just make a note of it and reread your notes of this presentation from time to time as you go. And again, by the way, after the presentation, you can email either Kelsey at SCORE or me, and we'd be happy to give you a copy of this deck too, so you don't have to take notes frantically as you go. All right, so again, we're going to start with making the app. What do you need to know about making the app? Well, there's a couple things. There's basically intellectual property issues that I want you to understand, and then there's the persistent question of, forming the company. Do I need to form a company? Well, sometimes, maybe. We'll talk about that. So let's start with that question first, actually, because it's sort of a threshold question. If you do need to form a company, you're probably going to want to do it before you actually submit the app to the app stores, because it's just going to make life easier if you don't have to change it afterwards from an individually published app to a company published app. Doable, but it's just easier if you don't have to do it twice. So let's start with the question of, do you need to form a company? It's an understandable question. And by the way, I'm bearing in mind we have folks on this call, I think, who are either a solo app developer doing something maybe as a sort of hobby or something maybe for financial purposes, but it's something that's not your day job. We also have people, I think, on the call who may work for a larger organization in Maine or outside of it, and part of the work that you do. And those are different sort of use cases. The legal issues are going to be the same, but for some of you, some of this presentation may be a little bit more relevant than for others. If you're the type of person who has not yet created a company, one question I'd encourage you to think about is, do I need to? And that's what we're going to talk about with this slide. Do I need to form a company? The short answer is no. There's no law that says you can't publish an app either in the app stores or just on your own website, or GitHub or whatever, without having a company. There's no law that says you have to do that. And if you do choose to publish through the major platforms, Google and Apple, they will certainly allow you to. If you read their developer agreements, and here's the 96-page Apple developer agreement that you're going to have to become familiar with if you're going to be launching an app. they'll say right in there, no, you can publish as an individual. For most people, that's fine. I mean, I don't know how many millions of apps there are now in the two stores combined. Last count, it was 9 million. Most of the developers are not companies. Most of them are an individual person just making it, and that's fine for a while. What I would encourage you to think about, though, is there are particular things, I'll call them trigger scenarios, particular things which, if this applies to you or if it later starts to apply to you, even if it doesn't now, these are the trigger scenarios that I think generally would cause you to probably want to form a company. Again, sort of your mileage may vary. These are things just to keep in mind and just sort of discuss with an attorney as you go forward. And by the way, quick timeout on that point. It is painful to try to find an attorney. If you need help finding one, here's your hack. Here's what you do. Call your local SCORE office. The local SCORE offices always have good relationships with good law firms and accountants and bankers and everyone you need to get your business going. If you don't have a SCORE office near you, talk to your business banker, talk to your accountant. Any of those three people can put you in touch with business lawyers who can help you do this. They can be in your home state. They can be anywhere you want to go. I see a question from Marty. I am going to return to this at the end. Thanks. And I promise I will. So hold me to that. So that's how you find a lawyer. Now let's return to this discussion of what we're talking about here. Here again are the trigger scenarios that may cause you to want to form a company if you don't have one through which to distribute your app. Well, first of all, if you have privacy concerns or if you have some reason you don't want your name to be listed in the App Store, because when you sort of click submit, finally click submit to Apple or Google, you do literally need to say who, you need to tell them who is the person or company that's publishing this. For privacy reasons, you may not want the world to sort of see your name. There may be a much more specific reason. Again, a lot of people who are publishing apps are currently holding down a day job as a custodian, front-end developer, database architect, marketing person at a larger company. You may not necessarily want your employer to sort of know that you're doing this. To be clear, I'm not suggesting you hide from them something you're not supposed to be doing, but it just may not be something you're really ready to have a long conversation about with. Obviously, don't do this if you have some employment agreement that prohibits you from doing this. But there's plenty of scenarios where people are legally perfectly able to do it, but they're just not ready to talk about it. They're in stealth mode, so to speak. That could cause you to want to form a company, because one of the nice things with a company, at least with an LLC, it's not always true with corporations. This depends on the state. But with LLCs, you don't have to tell anybody the name of the person who owns the LLC. You go from being, Jen Smith to, ABC Enterprises, and no one knows who's behind it. And ABC Enterprises is the only name that anyone can see in the App Store. So that could be one consideration. Other reasons why you may want to form a company through which to publish and operate your app are you have what I'll call significant risk markers. So that could be a significant number of users. Just got a lot of users. The more users you have, the more potential for something that can happen that could cause one or more of those users to decide to sue you or complain about you. Okay. It can happen. I mean, it's not an issue if you've got a couple thousand users. If it really takes off and you're the new Flappy Bird, if you remember Flappy Bird, all of a sudden you're potentially going to have a class action over some stupid thing because you sort of forgot to check a particular box with privacy compliance, which is unfortunate, but it happens all the time. So you've got a significant number of users, or maybe you don't have a significant number of users, unique users. You've got a small number, but it's an app that carries a price tag. It's an app that people pay a fair amount of money for. So large number of users, low or no price, or smaller number of people who are actually paying you money. Point is, the more people are paying you, the more money for it, the more potential for someone to take issue with something. An individual user, by the way, is not going to generally sue you. It would be a class action. There are class action firms who, for various reasons, sort of troll the internet looking for instances which a mobile app maybe wasn't compliant with all the laws, which happens 9 out of 10 times, candidly. 9 out of 10 companies that I've ever worked with or seen, even big name ones, they have not been 100% compliant with all the data security and privacy laws at every stage of their life cycle. It just happens. They're not trying to do anything wrong. It's a very technical area of law and they miss something along the way. And if you're a law firm that can find those, you can make a profitable business model out of suing those companies. So you don't want to be them. Also, if there are significant risks to consumers, or to, I should say, to users and customers, that might be a scenario where you want to form a company. And now, what do I mean by significant risk? Well, think about the nature of what your app helps people do, what they're doing with your app, and whether that might create a scenario where something like really bad could happen. So obvious example, one of the folks who signed up for this call, and I don't know if he actually managed to attend, one of the folks who signed up for this call I know works for a hospital, okay? If you work for a hospital and you have a mobile app that you are using in any way with your users, absolutely bad things could happen. If it's an app that they are supposed to be using to record their progress and sort of publish their healthcare progress with a particular condition to their physician or to their nursing staff, if your app botches that, bad things could happen to that person and to probably other people too. That's a risk situation for you. If you work for a bank, and every bank now just about has a mobile app, even small community banks, if the app somehow causes funds to be unavailable to a person because they used the app to make an ACH transfer or whatever it was, and they thought the money was in their account, it wasn't there, and they bounced a bunch of checks as a result. The point is, if you think about what your app is doing for people, it's not hard to think of scenarios where, again, sort of bad things could happen as a result of your app. So all those are risk issues for you. The more of these there are, the more it probably makes sense for you to form a corporation. The other scenario here would be if you have multiple people, multiple developers contributing intellectual property to the app. So it's not just you sort of with your laptop designing the whole thing. If you have anyone else, a business partner, a freelancer who you've hired through Upwork or TopTal or one of the freelancing sites, whatever it is, if anyone is helping you, the more people you have working on the intellectual property that is the app, the more likely you probably want to have a company. And I shouldn't say it's the more people, the more likely. Basically, think of it as a binary issue. If you're the only person doing it, then that in itself doesn't cause you to need to have a company. If there's two or more, you probably want a corporation. Because by default, every person sort of owns their own copyright, their own intellectual property. And the easy way to solve that when multiple people are involved is just have everyone assign it and give it to the company that is going to publish the app. Okay. So why don't we move on? What kind of company to form? Just real briefly, in the United States, there's only there's a lot of types of business entities, benefit corporations, partnerships, et cetera. The only two that are going to really make sense for you if you're in the United States are going to be an LLC, which is a limited liability company, or a corporation. In every state except for New York, an LLC is almost always going to be the right way for you to go if you're just one person sort of creating an app and you want to have basically a company to protect your personal assets. In New York, there's some funky rules about LLCs. They're common, but they can actually just be more expensive than corporations. So the bottom line is here, just again, talk to a lawyer in whatever state you're located in. He or she can advise you on the best way to go. If you do need to form a corporation, the good news is incredibly easy to do it. With a couple $100, literally, you can have a company formed in 48 hours if you really need to sort of expedite it. So it's not something that should slow down. If you realize at the last minute before you submit your app to the app stores, oh, I should form a company, it's not a crisis. Just take 48 hours, form the company, get it set up, and then by the time you finish that paperwork, the company will be formed and you can just submit it to the app store. And now it's ABC Enterprises submitting the app and not Susan Smith personally. A lot of people ask about Delaware. If you read a lot of blogs about sort of software development, there's a lot of people saying, well, you need to be a Delaware corporation. What is that all about? It's a common question. Those are skewed heavily in favor of companies that plan to grow very fast, very quickly, or companies that plan to issue stock options or stock to their employees. So basically, if you're one of those kind of startups developing an app, it may make sense for you to be a Delaware corporation right off the bat, even if you're not located in Delaware. If you're California or Maine, New Hampshire, wherever you are, it sometimes is absolutely the right thing to do. If you're not one of those companies, don't worry about it. Just you can always change later. In fact, it's very, very common if you have friends who are working at companies that have been acquired or have had like a Series A investment from a venture capital firm, you'll notice if you look at their publicly available filings, often around the time that they get their first round of financing, they have switched from, like, let's say, a Maine company to a Delaware corporation. And the reason for that is very simple. It's because the investors don't invest generally in those local companies. Investors almost always say, professional investors, I should say, not like friends and family. Venture capital firms, a lot of angel investors will say, love your product, we love your company, we'll be happy to invest with you. As part of this, you need to switch to a Delaware corporation. No problem, it's doable. All right. Questions, I'm keeping an eye. I see one question I'll return to later about patent issues, but otherwise, I guess I'm not seeing any, so I'm just going to keep proceeding. Okay. Again, big picture in the roadmap, we started with making the app, talked about when and how to form a company, Now let's talk about the intellectual property and contract issues. Sorry, just lost my thing here. Making the app, when you're literally writing the code and putting everything together into the bundle that becomes the app, the main areas of law that you want to understand are really contract law and copyright law. Occasionally patent law. People say, you know, can I patent my app? Short answer is talk to a patent lawyer. I'm happy to put you in touch with some. I'm not a patent lawyer. I would never pretend to give people sort of useful advice about patent. What I can tell you is that the vast majority of mobile app developers will never have a reason to sort of talk to a patent lawyer, at least not in the early stages, because it's incredibly expensive. It's not like copyright or trademark. It's very affordable. Patent, they're incredibly expensive. It can take years to even get a decision from the Patent and Trademark Office about whether or not you're going to receive a patent. And by that time, you know, generally, you know, your product has changed so much that you may not even be doing the thing that you were doing 4 years ago when you applied for the patent. So it rarely makes sense, but you know, in select cases, it may make sense for you. So let's talk about how US law views mobile apps. And when I say US law, you know, again, in the United States, if you're in the United States, which I think most people on the call are, we live in this sort of two-tier legal system. We have federal laws that we need to comply with. We also have the law of whatever state you're incorporated in, as well as the law of the state where you're actually physically based, which could be different. Again, California or Maine company that's actually a Delaware corporation based in Maine, you want to be complying with the laws of all of those, all of the above. So how the US laws view mobile apps. I always like to start by just remembering, going back to first principles, like what is the product that you're selling here? With every business, you want to be very clear in your own mind, whether you're selling seaweed or, you know, professional consulting services, or you're a lawyer selling your legal services, whatever you're selling, you want to make sure you understand what the law thinks you are actually selling, which may be different from the way you think about it. In our legal system, what you are selling or giving away, in the case of mobile apps, is a bundle of various assets that is developed typically by you as well as a very large number of third parties. That bundle of assets, the service that you provide, when you think about it, is really you create some new IP, you know, your own code, your own design work, whatever you do. Plus, you're also in the business of selecting a lot of existing IP that is typically either open source software that you think would be helpful for this product, or commercial proprietary software that you've licensed from AWS or Cloudflare or whoever else. And then at some part of this, you also hire some third-party developers, or maybe if you're a company, they might just be your employees, to basically write new code. So the resulting product that is the mobile app is typically, the key is that the service that you've provided is sort of like you've sourced a lot of IP, some of which is your own. Not always, by the way. You could be sort of a non-technical founder. You've never written a line of code in your life. You're not interested in spending 5 years learning how to do it. You just hire someone to do it for you. You do everything but the coding. That's fine. But the service that you provide, your vision is to source all of this stuff and put it all into one place that is now a bundle of rights. And what you're really selling when you sell a mobile app is you are selling the right to your end users to download that app onto their device or devices, to use that, to access it in ways that you are going to define in the EULA. So the EULA, it's the bottom right hand of the screen. The EULA, the EULA, that's the acronym that stands for End User License Agreement. That's a term of art that, you know, sometimes the actual document that your customers, your users are clicking to accept when they download your app, sometimes it literally is called EULA. But when I use EULA, and you'll see that a couple times in this presentation, it's a generic term that can refer to, you know, it's often called the terms of use, terms of service. It's whatever is that contract between the app publisher and its users. So that's the end user license agreement. So that's what you're selling. So everything that we're talking about in this presentation, I encourage you to think the product, it's not a physical good. Software isn't something you can touch. It's just code and files that, you know, an architecture that lives somewhere. If it's a SaaS product, it lives on someone's servers. If it's a mobile product, it just lives on your device until you delete it. That's it. That's all it is. So with that said, let's understand more about how we want to work with this product sort of in the wild, so to speak. The key area of law that you want to understand is copyright law. The copyright law is the area of law, this is a federal law, that protects the assets that together are the app. So copyright, of course, is the area of law that says if you are the person who owns the copyright, then what copyright means is the right to protect and prevent other people from making copies of whatever it is. So in the old days, before software, the old days meaning before, I don't know, 1960 or whatever software really began to be discussed in contracts. Copyright historically would apply to writing a play or a song or a painting or a work of art. When software became a thing, it became clear that that also applied equally to software. So copyright law protects all the stuff, the various components of the bundle that is that app. It applies to the source code. It applies to the user interface elements, at least some of them. There's some gray area about some of those. Particular user interface elements that are merely sort of functional as opposed to providing some degree of expression. Those tend not to be protectable by copyright, which begs the question, well, where is that line? It's a tricky line. There's some ground rules that you can discuss with an attorney. But basically anything that can be seen in the front end by the human user is going to be protectable by copyright. Your logo, any third-party art assets that might appear in their videos, all the stuff there, the content, that's all protected by copyright. So the key thing you want to understand about copyright law is that copyright law protects by default, and I emphasize default because you can override this with a contract, but by default, the copyright is owned by the person who creates the assets, okay? Again, this is different in some other countries, by the way, so the US legal system. By default, under US law, the copyright is owned by the person who creates the assets. In a second, I'll explain why I have an asterisk on that. So by default, it's owned by whoever creates it, unless, and this is important for you, unless there's a written agreement in which the person who created that stuff, the code, the artwork, the music, whatever it was that you want to have in your app, unless that person signs, it has to be a written agreement that transfers or assigns the copyright to someone else. So what this means in practice is that every mobile app developer, what we want to do is have a written agreement with whoever is helping you create your app. If it's someone that you hire through Upwork or Fiverr or one of those sort of freelancing sites, or if someone you just sort of meet out on the street and you want to hire them, or even if they're an employee. And this is why I put the asterisk, because some of you may be aware that under copyright law, there is a provision of the work for hire statute, which is part of the copyright law, that says if the person is an employee of your company, like an actual W-2 employee, not a contractor, but an employee, then generally the employer sort of owns whatever they create. And that's true, but I don't want you to rely on that because, and here's the part people forget all the time, that only applies if it's clear, very clear, that it was within the scope of that person's job duties to create that particular IP. And what often happens, especially in startups, I mean, startups, I've worked in startups, some of you have, you're wearing a million hats. You generally don't even have a written employment agreement. Your title may not be defined. It's not really clear that you were hired to do this as opposed to this. So to avoid that ambiguity, you want to have everyone who's working with you to create the mobile app sign a very simple agreement. It's not expensive. It's not complicated. It just says, look, you're going to help me create this app. I'm going to ask you to do X, Y, or Z. That could be back-end architecture. It could be HTML programming. It could be just create some written copy to display in the app, whatever it is. If you're going to help me do this, I need to sign something that's going to explain how much I'm going to pay you. And by the way, I'm going to be buying everything that you're going to be creating. I need to have that in writing. So if you take nothing from this presentation at all, literally the most important thing I can tell you is make sure that you never have anyone help you with your app unless they have signed one of those written agreements. They tend to be referred to as either a work for hire agreement or an IP transfer agreement or an IP assignment agreement. They go by a lot of names. Bottom line is you want that. So I think you get the picture there. All right. And again, what this looks like in practice, this is sort of a schematic that I came up with to sort of depict conceptually what a lot of people call the IP chain, the chain of intellectual property. So again, like I said a second ago, by default, intellectual property is initially owned by the actual human being who writes it. So that's your employees, your freelancers, your subcontractors. Then you want to have this intellectual property be assigned over to the developer. So this is you, if you're the person developing the mobile app. And then you also, in turn, and we'll get to this later in the presentation, once you're actually published, this is your EULA. You want to have a second written agreement that says that you allow your customers and users, sometimes those are different people, you want to allow them to use your app in a way that you're allowing them to. And that's just whatever is written into the EULA is what they're allowed to do. So the key thing here is that every stage in this chain, and there could be more of these, by the way. You could have, like, if you have an app that you design as sort of a white label app that is sold to, for example, I have a client that has a white label mobile app that they make available to large banks. Okay, that bank in turn puts their own logo on it. It's a white label product. They make that available now to their end users, the individual account holders, you and me. to the end user, they have no idea that this app wasn't in fact made by such and such a bank. They think it was made by the bank. In fact, behind the scenes, it was a white label solution. That's fine. That's routine. There's nothing wrong with it. It's not deceptive. But the point is there could be multiple layers in this chain. So the employers would sign their IP to the developer, which would assign its IP to the customer, which then assigns this IP down to whoever else down the chain. Okay, now a question that arises a lot with mobile development, just like the rest of the software world, very heavily reliant on not just teams of contractors who are often distributed teams, but specifically teams that are located around the world. It's very, very common, whether you're located in New York or Berlin or Maine or wherever, to say, oh yeah, we've got one woman who's in Madagascar, we've got another guy who's in Puerto Rico, whatever, Dominican Republic. You've got people all over the world. And the question arises, or hopefully it should arise, okay, how do we make sure that our contracts with them are kosher, they're legally binding? Luckily, not the end of the world. It's not particularly complicated. Typically what you do, just talk to your lawyer in the United States, wherever you are. What he or she is going to hopefully do is recommend that they check out the local law in that other country. Sometimes, not always, that requires finding another lawyer, but your lawyer can help you do that. The key thing to think about this is it's not that you shouldn't do that, but just talk to your lawyer early, because it can take some time to line up the right documents. It's not difficult, but it's not as fast as just giving your same independent contractor agreement to the next person that you meet in the United States. All right, now, what do you want to have in this agreement? And again, what we're talking about here is the agreement between you and sort of your labor force, the actual people, the individuals who are helping you create this app. And again, this is either your employees, if you're a company, your freelancer contractors, which you might be using whether you're an individual or a company, as well as like if there's an actual sort of development firm that you've hired. So you hired a firm in Portland, Maine or New York to just build your app for you. It's not a traditional freelancer, it's just a development agency. Whoever that person or company is, key things that you want to have in this agreement. And this is not an exhaustive list, but these are sort of the most important things that I can recommend to you. Absolutely critical. Again, you need to have that assignment of the intellectual property from that person or company to you. You'd be surprised how often people just don't have this in there. You need to have that. Otherwise, just to be clear what this means, if you don't have that in there, what it very literally means is that even though you just paid that person or that agency $100,000 to build this app for you, this prototype, $100,000 may not actually go that far, depending on what you're building. Even though you just paid them for it, you literally don't own it, and you don't have any rights to use that code or whatever they made for you, which means that you're actually committing copyright infringement. You're infringing their copyright until you get the rights to it. So you want to do this right. The other thing is you want that person or company to commit to not infringe intellectual property of third parties. To phrase that differently, these agreements should have, if you can Google, you can find a million examples of these template agreements. Somewhere in them, just do a Control F for the phrase warrant, which will pick up the phrase warranty or warranties. So there's typically a section in that contract that says warranties, and it will say the developer warrants, which means promises, not to infringe the intellectual property of other parties. And what that means for you is that if you're the client who's hiring someone, they are telling you, don't worry, you can hire me. In addition to sort of promising that I'm going to do good work, I'm also promising that I'm not ripping off someone else's code and repackaging it, which for you is good because it means you're not about to get sued because your employee or contractor has just ripped off someone else's work. By the way, when this happens, it's not usually intentional. I mean, the world is, the world is full of a lot of developers. Most of them are not intentionally ripping off code. It usually happens inadvertently. But the point is, if it does happen, you want to have a written agreement with them ahead of time that they will absorb the costs, in other words, the legal fees if that does happen. So those are critical to have in there. Other issues which aren't critical, but you may just at least consider. For a lot of people, these will make sense. In your developer agreement, you may want to put in some language about there rather than just sort of time and materials. You may want to actually agree to like a development cycle. I've got some clients that want to have a sort of standard sort of agile process with 2-week sprints at the, and throughout it you'll use like a sort of Basecamp or some other sort of Kanban system, Trello, whatever, to manage people's tasks. That's fine. You can be creative with that. You can have daily stand-ups and weekly stand-ups. The point is you can do this if you want. It's a good way to sort of build in some predictable structure to the relationship with you and your contractors. You probably want to have an NDA clause, some confidentiality provisions, it's not the end of the world if you don't. There are some default state laws about trade secrets that will give you some protection if you don't. But since you're going to be writing up this agreement anyway, it doesn't like add cost to your contract if you have a lawyer do this to add that. It's a standard clause, just put it in. One thing you may want to do, I've been doing this recently with some clients, it's been pretty successful. In particular, if you're using a developer located in any other country than yourself, negotiate and include a clause in there where you want to have ongoing access to the code. So if they're like most developers, they're probably developing the code in GitHub or Bitbucket or some other version control system. You can have a clause that says, at any given time, I have sort of real-time access to the code, or at least to some iteration of your code. And the reason you may want that is because if you have a falling out with this developer, which happens, it absolutely happens, you're going to be glad that you've had ongoing access to the code, and maybe you periodically download it or fork it off and sort of save a branch of it, because that's going to be your protection. If things go south, then the developer can't sort of hold your code hostage, which has happened to clients of mine a couple times. Again, this is particularly an issue if you have people in other countries. Why? No, it's not because there's something inherently wrong with people working in Romania or Ukraine or whatever. It's because if something does go south, you can't do what you can do in the United States, which is threaten to sue them. That's the ultimate sort of hammer that you have over people, is you say, look, we signed a contract. We agreed that if we had a dispute, I was going to sue you in New York. You can write those contracts with people in other countries, but realistically, the cost of suing somebody in another country is so staggering and so time consuming, you're just not going to do it unless there's literally millions of dollars at stake. You're just not going to do it. It's not going to make financial sense. So a good workaround is, it's sort of like a software escrow, is basically you have ongoing access to it. Finally, and then we can move on. The other thing to consider, you don't have to, but just consider whether you want to have a, this is the last bullet point here, a clause to give you, the developer, prior approval rights over any copyleft open source software. So again, open source software just meaning anything that's been published under any open source license as opposed to a proprietary license. There's thousands of open source software licenses in the world, but there's really like 4 or 5 that everyone uses: MIT, Apache 2, the various GPL licenses. Those are really what people are using for the most part. And if it's a copyleft license, like most of the GPL licenses, you may want to just ask your developers, say, I'm not telling you not to give me any code that's published under a copyleft license, but talk to me first, and don't give me any code that's copyleft until I give you approval first. And the issue for this is that there's some baggage that comes with copyleft code. There's nothing wrong with it, but it may cause security concerns, or the more likely issue is it carries some downstream repercussions. If you use someone else's copyleft code, you have to include certain types of restrictions and disclaimers on it downstream. For a lot of companies, you just don't want to do that for business reasons. So that's it. This clause will just make sure that you have a conversation so that you don't go ahead and launch the product only to later realize that one of the many open source tools that your developer gave you was something that has baggage in it that you don't want. That's all. I think you get the idea. All right, take a quick water break here. All right, no more questions, so I'll just keep on trucking. We've just finished the part of the presentation. Okay, hold on, I do see another question, and I'll take that one later too. Great. So we're at the part of the presentation now where we finished talking about sort of everything before publication, which is sort of when to form a company, and how to work with people who are helping you create the app. Now we're going to talk about actually publishing this sucker, which is what we want to do. And again, you don't have to publish through the stores. I do have folks who just sort of publish on their own website. That's fine. But the whole reason to go through the stores is you get access to billions more people than you do much more quickly than if you just publish yourself. So probably going to be publishing through the stores. I call this part of the presentation the laws of Apple and Google, because when it comes to enforcement, 99% of what I'll call the enforcement activities that take place in mobile app developments, which is basically, when I say enforcement, what I mean is removing apps, banning them. Probably 99.9% of the time that happens, it's not done by a government agency. It's not the Justice Department or the Federal Trade Commission. They do, by the way, they do this, just to be clear, and we'll see an example in a minute of where the Federal Trade Commission might basically sue to prevent you from distributing your app. But 99.9% of the time when it happens, Apple or Google is doing it. They are sort of the private law enforcement in this area. So we want to make them happy. They are the ultimate gatekeepers. Their decisions are final. You're not allowed, I mean, you can sort of appeal, but it's, you don't want to be in that world. So again, Google and Apple both have very long modular terms of use. These are the agreements that cover you as the developer. You want to be familiar with those. They are painful. They are not light reading. Sit back with a beverage of your choice on a Sunday afternoon, literally print them out, whichever platform you're using. If you print this one in 11-point font, it comes out at about 96 pages. This is the Apple Developer Program License Agreement. This is sort of the mothership agreement for developers. This will cover everything you're doing with the mobile app. There's also a couple other agreements for Apple. Google has a slightly different approach. Bottom line is you want to understand what you're agreeing to for a couple of reasons. First of all, because you literally need to comply with this before you can even submit it. For example, there's a provision that says you need to have a privacy policy with your app. And starting, I think fairly recently, maybe it's just Apple changed the way it was doing these, but recently I started having clients say, you know, I can't even submit it until I actually paste a link to the online privacy policy. That used to be the case that you could just sort of promise them that you have one, but now they're actually screening for that. So you literally can't even start the publication process until you've complied with this. But then once you do get approved, you know, you want to make sure you don't later inadvertently violate some of their terms, because that too can cause you to get yanked. And once your app is yanked, I mean, you've just spent a year developing something you can't use. So get to be familiar with these. I'm going to give you the real quick sort of 30-second summary of the key, 90-second summary of the key rules that are in these agreements. Don't rely on this. This is just sort of a sprinkling of the main rules that people tend to come into contact with and run into trouble with. I'll give you citations. A lot of these are in Rule 3.3 of the Apple agreement, and they're sprinkled throughout for Google. They're pretty straightforward. This is stuff that you've seen if you've read or written your own sort of SaaS licensing agreements. Most SaaS agreements have exactly this kind of language. They're sort of routine in software. The app, so again, this is the agreement you're applying, you are promising to comply with when you're submitting your app. You have to comply with the law. Pretty straightforward, right? Apple says we don't want people publishing apps on our store if they are engaging in violations of law. That's bad for us. That can expose us, Apple or Google, to liability, maybe. We just don't like to deal with criminals, literally criminals. So you have to comply with the laws. Okay, straightforward. Okay, another thing to say is Apple and Google are asking you to promise that your app will not infringe on third parties' intellectual property. So this is exactly the same issue we talked about a second ago. Remember that section I was talking about things you want your own developers to promise you? You want them to promise that if you buy their code from them, you're not signing yourself up for a lawsuit from a third party who says, hey, they stole my stuff. Exactly the same issue for the same exact reason Apple and Google are asking you to promise that if you submit an app and if they choose to publish it, they're not going to get sued by a third party who now sues them, claiming that you ripped off someone's IP. See, so it's the same issue that sort of continues downstream, sort of the metaphor downstream with the intellectual property. At every stage in this, whoever is the next person in line usually asks the person who they got it from to make the same type of promises. So that's why we're seeing this. So yeah, you're going to be promising them that you're not infringing on third-party IP. Specific scenario where this is a huge problem for a lot of app developers, depending on what your app does, what features it has, is if the nature of your app is such that it allows human, individual users to post content for publication, videos, images, Snapchats, text, whatever, that can create some risk for you because you're not, unless you're doing what some companies actually do now, which is you have to screen it before it goes live, but the cost and the hassle and the friction of doing that is almost always prohibitive. Even Facebook doesn't do that, famously. So typically what you do is you just have sort of a publish first, review later system. As the app developer, we say, I have made an app, you, the user, can use this. Let's say Twitter. One of the things that you can do with my app, in addition to just reading other people's stuff, you can publish stuff. And so if you read the terms of use for Twitter, Facebook, Stack Overflow, Quora, any product, SaaS or app that allows you to sort of write stuff or post a video, YouTube, post a picture, they're all going to have them in the same clause that says you, the user, are promising that you will not be publishing stuff that infringes other people's intellectual property. So Apple is asking you to make the same promise. You also are going to need to promise the platforms that you will not interfere with other apps, because this is a quality concern issue, a reputational brand concern, more than a legal issue, where, you know, Apple wants you to promise, look, Apple is not going to survive very long if it designs its platform in a way that allows one user to make life really difficult for other users. I'm sorry, not users, developers, okay? If Apple doesn't create a system that helps protect developer 1 from misconduct by developers 2, 3 through 10 million, it's going to start to lose its developers, which are obviously critical to the platform continuing. That's what platform is. It's just a toolkit for developers. So one of the things you have to promise to do is not interfere with the way that other apps are working. And there's, you know, I mean, take a look at the actual rule. It's rule 3.3, I think. But among other things, you can't squat on names. If you can't just sort of like name your app something if you have no legitimate sort of, you know, desire to sort of use that name in connection with your product. You can't confuse consumers, you know, things like that. Don't be a jerk, basically, to other developers, which is different from your agreement that you're not going to be a jerk to your users and your agreement not to be a jerk to Apple. So these are all the promises that you're making in the developer agreement. Okay, and again, just a couple more examples of key rules that people are in trouble with. No false reviews through websites like Fiverr. Fiverr is a popular one where people get in trouble. It's really easy if you're a developer who is not exactly ethical or ethically challenged. It's very, very easy to find ways to pay people a small amount of money to create a bunch of fake reviews. You know, 5-star review. I downloaded this product. I loved it. It's my favorite game I've ever played. It's a health app. It cured me of my cancer. I mean, you know, that just to be clear, that is absolutely illegal. So it not only violates the Apple and Google terms of use, it also violates the Federal Trade Commission Act, which is the main American federal law that deals with deceptive advertising. And we'll come back to this in a little bit, but totally illegal. And you also shouldn't do it because it's just you're lying to people. So hopefully your own ethical code would tell you not to do that. But I've worked with startups who have said, yeah, but it's, you know, I mean, come on, for our first, you know, we just need to get some early user reviews so we can get people using the app. We don't want to look like it's a ghost town here when people look in the App Store and they see no reviews. Don't do it. Don't do it. Or rather, there's another way you do it, which is give free beta access to a lot of people and don't ask them to review it, but trust that some of them will. If you give it to 100 people, some of them will write a review. You know, that's the way to do it. But nothing wrong with that. But don't get people to do it. Don't ask them to do it. Don't pay people to do it. That'll get you booted very quickly. And every once in a while, if you follow the blogs that follow, that basically are sort of the roundups of the latest enforcement actions by Apple and Google, you'll see, oh yeah, you know, another 2,000 people were banned yesterday because they're using sock puppet accounts to write like fake reviews. Or a company, this is the other thing companies love to do. You know, they'll have their own employees to sign up and write reviews. Totally illegal. Don't do that. Other things, no dishonesty. Don't do bait and switch pricing. Don't say it's a free app in the App Store. You know, so what you don't want to do is say there's a, you know, the App Store description will say it's free, but then it actually, you know, charges a fee once you try to download it. You know, you don't want to have bait and switch pricing. You don't want to have misleading claims or language. You don't want to say, and I'll show you some really funny screenshots in a second of where people get in trouble. But just, you know, think of it like the golden rule. Like, you know, think of it like you have to defend your mother, your father, your friend, your significant other, what you're doing. Don't be a jerk. You know when you're saying something dishonest. Don't say misleading things about the quality of your app or how it works. That'll get you booted in addition to violating the law. And to be clear, again, this refers to things that you say in the app itself, the actual thing that people see or hear or whatever in the app, as well as things that are written into the App Store listing, directories, or anywhere else. If you advertise online, you know, if you're a game that advertises in another game, you know, if you play any of the popular, you know, Words with Friends or Zynga games, you know, you're constantly going to see other game companies advertise their games. So if you're advertising in your own game, in someone else's game, you know, Twitter, wherever you're advertising, don't be dishonest. And then finally, you know, Google and Apple, again, this is all under the heading of the rules that you're promising to comply with when you're developing apps. You have to comply with the privacy laws. You know, privacy laws, what do those mean? Well, for most apps, that's going to be California's privacy laws. California is, say, famous or infamous for updating its privacy laws, you know, sort of almost on a sort of annual basis now. We've just barely begun to sort of figure out what the new CCPA means. If you recall, CCPA is the California Consumer Protection or Privacy, I forget, Privacy Act that passed and took effect. It was a voter-approved referendum that took effect January of this year. We barely had finished reading that. Literally the final regulations to implement that were finally published by the Attorney General's office, like I think 5 or 6 weeks ago. And already California has now adopted a new one. They did this last Tuesday. You may have been distracted by some other election news that was in the headlines for last week. But yeah, one of the things that California did is they passed yet another privacy law. So those are always changing. Generally, those laws, even though they're California, they typically apply to people located anywhere in the United States. That may not be obvious why that's the case, but the answer is that many of the things that you're doing with your app will affect California consumers. So just that the assumption should be that you're bound by California law, even if you're not located there. And by the way, it's not necessarily bad news because it's not hard to write these privacy policies. Now, if you're in particular regulated industries like healthcare, financial services, or ed tech, in Maine in particular, there's like a whole slew of companies doing various software applications that work with either high schools, lower schools, post-secondary, anybody in ed tech, educational technology. All of these have additional privacy rules that are much more robust. And healthcare, of course, it's HIPAA. We're all familiar with HIPAA just as patients. There are similar rules with financial services or education, a couple other industries. If you're in cannabis or if you're in any of the software fields that are sort of adjacent to cannabis, there are really some wonky issues there because it's still absolutely illegal under federal law. The point is certain industries have additional privacy rules, but all industries, no matter what you're doing with your mobile app, you want to think about these California privacy laws. And with respect to Google and Apple platforms, what that means is not only do you have to comply with those, but you also need to post a privacy policy either on your website or in your app or both, depending on, you'll see, depending on how your app works, it may be one of those or the other. They'll tell you when you try to publish. Finally, you'll see there's multiple requirements in the Google and Apple developer agreements, these beasts of these documents, multiple places where slightly different issue from privacy. There are other laws, data protection laws and consumer protection laws that require particular types of disclosures that need to be made to consumers. For example, again, some apps have features that use facial recognition technology. If you do that, there's a particular type of disclosure you need to make, and it'll tell you where during the user experience workflow that needs to happen. So the point is there's details there, just sort of look into them if that applies to you. All right, we're about halfway done, which is good because I think we're about halfway through the deck. Great. Keeping an eye on the chat. Okay. Okay. And again, this is just finally still a little bit more on the question of what do you need to do to not violate the Google and Apple sort of developer agreements. Another one of the things you want to keep out. This is, if you want to look in the Apple agreement, it's section 3.3.10. So just look that up online. By the way, if you haven't yet published your app, if you have not yet published, one question you may be asking yourself right now is, where in heaven's name do I actually find this agreement? Because it's not easy to find online. It's easy to find once you're actually into the publication workflow. But if you're someone who has not yet published, it's actually hard to find it because it's behind an Apple, it's not a paywall, but it's like a screen. So just Google it, see if you can find it. Reach out to me, I'll give you a copy if you want. But basically it's the threshold question is actually finding the agreement itself. Because it's not just like there on a website, it's behind a wall. But 3.3.10, if you have the agreement or if you can get it, is the section to look at. So what you're promising as the developer is you're promising that you're going to prevent unauthorized disclosure of user data. In other words, there's a general promise they're going to try not to make an app in a way that's going to expose people's personal information to hacking or to breaches or whatever. And if it does happen, and it's more of a, it's the old saying is sort of designed for failure. The old saying in a lot of software is designed for failure. Sort of assume that at some point your app will be hacked, because there's a good chance it will be. It's not the end of the world. We have an evolving legal system that increasingly realizes it doesn't mean you're a bad, irresponsible actor if that happens, because it's really hard to prevent. So you don't have to promise that it's never going to happen. You have to sort of promise that you make reasonable efforts to do that. And what that means, there's some very specific technical answers to that. But if it does happen, in addition to promising that you're going to try to prevent it from happening, you are promising that if it does happen, you are going to notify users in the event of a breach. So that's one of the things you're promising, Apple. Now, you would be legally required to do that anyway, but just to be clear, if you don't notify users of a breach, or if you don't make any sort of efforts to keep people's information secure, not only are you potentially violating laws and risking a lawsuit from those users, but you also are risking getting booted from the app platforms, which is going to be very bad for you. Now, I have a little sort of footnote on the slide. Note that depending on what state you're in, and the state laws on this are a totally crazy patchwork. New Jersey has different laws from New York. There are even some individual cities, like I think Austin, Texas, has some particularly sort of consumer-friendly protections that go well beyond what Texas state law requires, all of which go beyond what federal law requires. So it is total patchwork. But bottom line is local law may impose some additional obligations on you in the case of a breach. For example, they may say that before you can even notify users, before you can even notify Apple or Google, you have to first call your local police station and notify law enforcement, or in some cases, maybe it's the FTC, depending on how the law is written. But just all you need to know here is develop some familiarity with those laws, because in some cases, you may literally need, your first call has to be to the police station, and they'll say, okay, you can't notify Apple of the data breach until we've given you the all clear. And the reason for this, of course, is clear to you if you've ever watched any TV drama about the cops, is they need some time. They have a little window of time where the people the perpetrators aren't yet sure it's been discovered yet, and that's an important window where they need the ability to do some law enforcement activity before you start telling everyone and their brother. So just check your local laws. Okay. Finally, what do the platforms themselves, what do the Apple and Google developer agreements say about what needs to be in your own end user license agreement? Well, if you look at the Google Play Developer Distribution Agreement, which is Google's version of this monstrous Apple agreement, look at section 4.7 of that Google Play Developer Distribution Agreement. That one I think is actually online, unlike the Apple one. That's sort of a lightweight version of what we find in the Apple agreement, Schedule 1, section 3.2. Again, I'm giving you these citations so you can actually just look them up and just find them on your own time for your reading pleasure. But Schedule 1, section 3.2 basically says, look, you don't have to have your own custom written EULA, you being the developer. You're welcome to. If you don't have your own custom EULA, you're gonna, we're gonna just sort of insert in its place the default one that's written into the App Store Terms of Service, which is yet another agreement. That's not the one I keep waving around like a Miami-Dade County election poll worker here. Basically there's some default terms that we're going to apply to you and your users unless you have your own custom agreement. So that's it. Basically, here's the default. If you want, you can override that with your own custom agreement. But, and you'll see this written in the Apple Program License Agreement, if you use your own custom EULA, which I would encourage you to do, you need to include some minimum standard provisions in there. And if you literally do a Control F in that document, I forget if it's in Schedule 1, there is a document that's just titled Minimum Terms for Custom EULAs. And what that says, Apple is saying to you, you're free to write your own EULA. It's probably a good idea. If you do that, here's some stuff you, the developer, need to actually put into your own EULA. So what that means is things like, if a user has an issue with the app, they need to call you. You're going to tell them not to call us. Apple does not want to be fielding phone calls from consumers who don't understand how to use your app. Apple doesn't know how to use your app. They know how to review it for publication, and they know how to charge you money for it. That's what they know how to do. They say, you're the developer, you should be fielding customer service questions. There's some other stuff in there too, but the point is, find that part of the agreement and just make sure you and your lawyer take a look at that. It's easy to do. It's simple language, but you need to do it. Okay, we just talked about a bunch of rules. What happens if you violate these rules? Are there any teeth there? Absolutely, the rules have teeth. I've given you a sort of screenshot here from a blog that you may be familiar with. If you are an Android Google developer, you may follow their Google security blog. If not, take a look. It's where you find the latest information about things like when and how Google boots apps. One of the reasons they boot apps is because apps are violating their laws. Their rule, well, yeah, essentially their laws, but the rules. So this is one from earlier this year. Maybe you saw this cause a little bit of a ripple in the sort of trade press and hacker news when it happened. Google announced, and I've sort of very dramatically circled it here. One day Google said, February this year, Google said, we just booted 600 apps from our, from our platform because they were violating two of our rules that we are increasingly concerned about, which is the rules, and I've circled those at the bottom, the rules on interstitials and disruptive ads. So these are two similar types of policies. Again, these are modular documents. You'll have sort of a general developer agreement, which usually has hyperlinks to like a dozen other different agreements. It'll be a different agreement, one policy on use of Google trademarks, one policy on interstitials, one policy on privacy policies. And if you violate any of those, it means that you in turn are violating the master agreement, which means you can be booted. And they do absolutely do on an ongoing basis. They're doing audits, either because they've gotten complaints from users or because they're just doing it. They have roving sort of their own private law enforcement that is constantly trolling the app stores, just randomly, pulling apps and saying, what are they, how are they actually doing things? As a result of one of those operations, Google yanked these 600 apps because they're doing interstitial ads, which are those annoying little pop-ups that you see in certain types of ads. They were doing it in a way that they thought was too annoying to the users. And again, you may ask yourself, why does Google care about this? I mean, if I'm doing something that is causing problems for my users, isn't that really a problem for the app developer? Well, yes, it is, but it's also a problem for Google at some point. So that's why Google says, we're going to ask people not to be really jerks like that. Sorry, you may be able to hear my cat meowing in the background. Sorry about that. Okay, so let's fast forward now to, we've got about a half hour left. Now that you're published, now that your app has actually been published, so we're fast forwarding, again, we're progressing through time. Now that your app has actually been published by Google or Apple or both, if you're in both platforms, what do you want to think about going forward? What are the legal issues you want to think about going forward? Well, we want to talk first about the user-facing agreements. So we've talked about this a little, but I'm going to flesh them out. Again, you want to have a EULA. And again, as we just saw, if you don't have your own, you're going to be bound by the default one that Apple sort of has. It will literally make that available to your users without your sort of consent. So it's okay, but consider having your own. Why you want to have the EULA? We've talked about what should be in it, but in the big picture, why do you want to have this EULA, the end user license agreement? Well, it's because this is the document where you get to define as narrowly or as broadly as you want what exactly people are allowed to do with your app. You've just spent a ton of time, possibly some money, some mental energy creating this app. You want to put a lot of thought into what people are actually doing with it, not just because there are legal risks that can attach when people use it in different ways, but because it's your product, it's your baby. You're the master of that. You get to write this however you want. So you want to do that. You're going to be giving the users the right to access the app, download it, use the app, as well as use the content that's in the app, which is sort of different. There's different rights that attach to those. In particular, if it's an app, particular types of app that involve users being allowed to contribute their own content, which of course is not all apps, but some apps, that's a different thing from just the app itself, where you as the app developer write the content that appears in it. Now, and again, in certain types of apps, anything sort of like a social app where it depends on users being able to communicate with each other, if it's that types of app, if it's that type of app, you as the developer are also going to be potentially, probably giving each individual user the right to reproduce and read and use and sometimes publish content written by other users. Which may not seem intuitive, but sometimes you may want to do that. So for example, if you use Quora, which is one of the question and answer websites similar to Stack Overflow, there's a lot of them like this. Look at some of those in the terms of use. You'll see in the license section, it'll say, you, the user of this app or this SaaS platform, are allowed to not only use our product to sort of create your own content, publish your own content, but in some cases, you actually can sort of use and copy and republish stuff that other people have written, which may theoretically make the other users mad, but they do that because that's the way the product grows. The product grows and its base grows by having more people use it, tell people about it, which means publishing. Now bear in mind, again, not all apps, but many apps, in particular one where the users are allowed to publish their own content through your app, it's very important that you have the EULA for a different reason, not just because you want to make clear what rights you're giving to your users, but you actually need them to give you rights. Remember, back when we saw that little arrow flowchart, nobody has the right to do anything with anyone's copyrighted material. Words, images, videos that they've uploaded, text, whatever it is. You can't do anything with it legally until you have gotten the written permission from that person to do it. So part of what you're doing, if you're Facebook, is you're saying to the user, not only is my end user licensing agreement defining very carefully how I want you to use my product, but I'm also giving myself the legal right to use whatever you type in here, or contribute here, or upload here, and you're going to be okay with that. You're not going to be upset at me if I do that, because you're giving me a license to do that. Okay, let me skip to the next slide. Now, a question that comes up a lot, and this is where it gets really fun, because we get to look at actual screenshots of documents in the wild, which is much more fun than thinking about them in the abstract. The question that comes up a lot, and it's a very important one that's going to confront every app developer. How do you make the end user license agreement binding? Like literally, mechanically, how do you have to, I mean, we're not talking about a situation where people physically sign contracts like they would do if they're buying a car or a house. How do you actually make this a binding contract? Well, luckily, we've had about 40 years of courts looking at cases that sort of debate what this means and what's okay and what counts. So we have very clear answers now. There's a couple ways you can do it, and I'll tell you how I recommend you do it. The ideal approach is a simple click-through agreement, just like you'd have with most SaaS applications. By the way, most of this presentation, we're talking about issues that come up with mobile app development, but 99% of this applies to SaaS applications too. So if you're selling a SaaS application, this would hold true for this as well. The gold standard, the way you want to do it is sort of a click-through agreement, right? The user has to literally see and click through, usually in the form of a pop-up. They're sitting there on their phone, they've downloaded the app, great, but now they literally can't get past this annoying pop-up until they see and click through in the user interface a pop-up or something that shows them the actual hyperlinks to both the privacy policy, which again is required by law, and the platform terms, as well as the end user license agreements. So Twitter, perfect example. If you look on the right side of the screen, the way Twitter did it, I'd be very happy as your lawyer if you did exactly this. Again, they've checked the right boxes. So this is what would be seen, not at the time that a user logs in every time, but the time that they first create an account, at least on the mobile app. This thing is optional, the tailored Twitter, that's fine, that's an optional thing. But the key here is at the bottom, by signing up, you agree to the terms of service, which is the way they've referred to their EULA, and the privacy policy. By the way, you'll notice Twitter has done something a lot of companies choose to do, you don't have to do. They have a separate policy called the cookie use policy. Let's just talk about that for a second. A lot of companies do that. It's not legally required. Why would you do that? Why wouldn't you just incorporate that, fold that right into your overall privacy policy? Because it's a privacy issue. Cookies are a privacy issue. Generally, I usually put those in a privacy policy. Situation where it sometimes makes sense to break that off into a different document is if you anticipate that you're going to be changing the cookie policy more frequently than you might change the overall privacy policy. That could happen for a lot of companies. You say, no, we change this from time to time. We're always experimenting with new cookie approaches. In that case, the benefit of this approach is you don't have to update the entire privacy policy every time you want to change just the little thing that deals with cookies. You just sort of incorporate it by reference, and then you just tweak this, and then it's good to go. So the way Twitter has done it is fine. Now, what people sometimes ask is say, well, can I just do what is essentially like a browse wrap agreement, or sometimes called browser terms, which is, there are terms of use there and people can find them. I have a link to them at the bottom of the screen, but I don't actually hit them with a pop-up. You can do that. I'd encourage you not to, because there's a lot of ambiguity in the law, and this issue varies a lot from state to state. State laws are all over the place on this. I can tell you the law in Texas and Maine and New York. I have no idea how it works if you're in Idaho or Alaska, Wyoming, but states are all over the place. But in a lot of states, there's a real significant question as to whether that's legally binding. In some cases, the answer is actually not unclear. It's clear that the answer is no, it's not legally binding. So another way to say that is it's either not permissible at worst, or at best, it's unclear. We don't want an unclear situation. We want a clear situation. We want you to be very comfortable that your EULA has bound people. This is the way to do it. Now, another question that comes up, Why is it though? I sometimes see companies that have gone way above and beyond this. So Microsoft, some of their products, for example, when you first start using them, they not only show you this pop-up, but they literally put the entire text of the EULA, which is like 80 pages of, 1-point font in front of you. And then for good measure, just to make life even more difficult, you can't click through it until you've actually scrolled down for 45 minutes to the bottom of that. Why on earth would they do that? Well, the answer is because they think that gives them some additional protection in the event of a hypothetical lawsuit. What they would say to the judge is, Your Honor, we've been hit with a class action lawsuit. We've got 50,000 plaintiffs across the United States are claiming that they didn't realize that our terms of use contain this section 11B that said we had a particular type of thing we're allowed to do with their data or whatever. But Your Honor, we could not have possibly made it more clear. Not only did we put this in front of them, they had to click through it, but in fact, we didn't just put a link to it, we put the entire thing. Not only that, Your Honor, we were so diligent, we were such Boy Scouts that we made them click through the entire thing before they could do that. You can do that. You wouldn't want to do that for most people because it's a lot of friction. People don't like friction. If you run an A/B test on those two different user experience workflows with a large enough sample set, you're going to see that you're going to be losing some people. You're going to have people who sort of bail. They download the app. There is a percentage of people who's going to say, too much work, I'm not interested in using the app. Now, one of the reasons Microsoft, I'm guessing, does that is because the nature of their distribution model, so much of their software is being used by people who were told to use it because their employer gave it to them, that they don't meaningfully have an opportunity to not do that. So it's not a situation where you're a new sort of scrappy startup where you have to really sweat bounce rates when people are downloading your app. So again, bottom line, I would be totally fine. I wouldn't recommend you do less than what you're seeing on the screen here on Twitter. I don't think you need to do more. You certainly can, but it's probably too much friction for people. Okay, we're almost near the end, and we'll switch to some other issues. How to make EULA updates binding. So again, the last slide was how you make the original EULA binding. What about updates though? You're going to be updating it periodically, and your terms of use, your EULA should have a thing usually at the top that says, by the way, we're going to update this periodically. We're not necessarily going to email you when we do it. So just bear in mind that if we update it, we're just going to post it here. And if you continue to use it afterwards, you're bound by the updated version too. How do you want to handle this? Again, I'll give you a best practice and then talk about some of the options. The ideal approach is do it exactly the way we just saw with Twitter. Here's just a different example from Zynga, popular mobile game developer. So you would see this not at the time that you first use them, but every time they update afterwards. This is sort of the gold standard. This is the way I'd love to see you do it, which is you get a new pop-up. You want to play your Words with Friends or Candy Crush or whatever Zynga makes. You want to play that game because it's 11 p.m. and you're half asleep and you want to play the game. You can't do it until you click to say, I realize that you have now updated the software. That's great. Again, for a lot of people, that's too much friction. So what you could do, and it would be probably fine, there's a little bit more risk, but you could do it, is just have a persistent banner for like 2 weeks after you update the app. Just roll out the update to people. You don't have to tell them, you don't have to get them, you don't have to email them. Just put a banner the next time, for the next 2 weeks, anybody logging into the app, or have it triggered by someone who is visiting for the first time after an update. Your engineers can design that for you. If the first time you look at this after the update, there's going to be a banner somewhere in the actual interface. You don't have to click through. It's just there looking at you. And it says, just FYI, we haven't updated terms of use. That's fine. That'll be okay. App privacy policies, we've talked about this already, but basically the bottom line is you need to have a privacy policy. You need to comply with whatever you say in the privacy policy. Privacy policy, of course, what you're basically telling the world is how we collect user data from you or about you. This could be two different things. Some of it is data you're going to give me. Some of it is data I'm getting about you from third-party like advertisers, if you're doing that, which not everyone is. You need to tell people how you're collecting the data and then what you do with it, who you share with it. All right, let's talk about the key advertising laws that you want to be aware of and compliant with your mobile apps. And again, this happens to be in the context of mobile apps because these are the laws that I usually see people get in trouble with and try to help them out of. But it's not like these only apply to mobile apps. So these apply with any software. They apply with anything you do in business that is within the scope of these laws. So the first thing, again, we talked about deceptive advertising. When people talk about the false advertising laws or the laws against what, strictly speaking, is called deceptive advertising, which is a little bit broader than just false, because it also includes like sort of implied deceptive statements, as opposed to clear express statements. The main federal law that we're talking about is Section 5 of the Federal Trade Commission Act. It's a weird name for a law. You'd think it'd be called the Deceptive Advertising Law. The fact is, it was Section 5 as part of a much broader law that created the Federal Trade Commission, which is one of the two federal agencies that enforces these laws, along with the Justice Department. So that's it. That's the main law, and what it says in a nutshell is anything you do in business, whether you're selling chickens or seaweed or software or healthcare services or whatever you're selling, you can't lie to people. You can't lie explicitly. You can't lie by omission. You can't lie implicitly. You can't lie to people. You can't be dishonest with people. Now, the particulars of that mean a lot of different things, but that's the general rule that we want to bear in mind. Now, what does that mean for mobile app developers? Where do mobile developers get into trouble? Well, it's often with things that are written in the app itself, as well as about the app. And let's take a look at some examples where people have gotten into trouble with this. Mobile games are notorious for this. I like to play Words with Friends with my wife and a couple other friends of mine, so I'll sit there and play Words with Friends. I don't think they've gotten in trouble, but a lot of the mobile game apps are just a breeding ground for this kind of deception. So there's if you look, I've credited the YouTuber named 13stars. I have no idea who he, she, or they are, where they're located, but that user account, if you want to have some fun, look at their account and take a look at all the examples they have curated of sort of hilarious fails where a mobile app will show you an ad suggesting that their game looks and works in a particular way, and then you actually pay and you download the game, and it looks nothing like it, or it's like a very, rudimentary version. You thought you were getting a Cadillac for your $4.99 download, and you're getting a Pinto or whatever. So you don't want to do that. That's the bottom line. That's what I'm talking about here. This is deceptive. And if you do this badly enough on a large enough scale, you will get sued. But long before you get sued, you will just be taken down by Google or Apple, which is, sort of, you won't even get to the point of being sued because no one's going to be able to see your game anymore. And if you do it with one game, maybe the worst that happens is they get rid of that game, but now your developer account has been flagged as suspicious by those platforms. So now you're going to have a problem in the future. Now, in some cases, you can use a written disclaimer, because you can have, to some extent, the advertisement doesn't have to look exactly like the actual game or the app you launch. You can sort of walk it back a little bit by having some fine print near the end of the advertisement that says, by the way, this is sort of an example. This is an artist rendering. You have some latitude to do that, but it's not always going to save you. Here's an example from the BBC News just, I guess this is just a couple of weeks ago. There was an app called Homescapes and Gardenscapes. I don't know the game, maybe you've seen it. There was an ad that it was a game where you basically like are a little avatar and you are gardening, like you're a video game gardening game. And apparently they had a misleading advertisement according to the ASA, which is an English advertising industry group, which also is a de facto regulator. Now they are an example of an app publisher that did actually have a brief warning at the bottom of their video, their advertisements, that said, so they tried to sort of dodge this issue by showing an intentionally different experience than what people are actually going to get. They thought it sufficed just to have a little written thing at the end that said, not all images represent actual gameplay. But the regulatory agency here, which in this case is the trade association, said, it's not good enough. You're still deceiving people. Bottom line is the app is now banned. Again, under the heading of just miscellaneous laws to be aware of and comply with, you want to be aware of the CAN Spam Act is the main federal law that deals with spam, unsolicited mail. So one thing that a lot of apps do, what a lot of app publishers do is, your app works hand in hand with your advertising campaigns, right? Which may not just be advertising your app, but other apps that you offer. So if you're a company that offers a bunch of apps, you'll have people sign up for app number 1. As part of that workflow, you get their email address. You now add that to your general sort of constant contact or whatever it is, MailChimp. And now you start blasting those same people with emails saying, hey, you like this game so much, maybe you want to buy our other game. It's a common, natural thing to do. You can do that, but if you do that, if you use their emails that you've gotten through the mobile app, you need to comply with the spam laws. So basically, all the stuff about you need to put an opt-out link in those emails. You need to review the rules relating to, there are different types of emails under the law. There's sort of transactional emails, which are okay to send Even if someone told you they want to opt out of your emails, that's fine, but you need to know exactly what those are. And basically what you usually end up doing in practice, if you're a large company, is you have sort of a master checklist. You have different emails doing different email campaigns. You have different channels that are gathering email addresses from people. And you just have one master checklist, one master database where it's sort of your block list. Here's all the people who have said from many, many angles that they don't want to get our emails. And then any outbound email, you just run a check and make sure it's not on that list. If so, it gets blocked, it doesn't go out. So it's conceptually, it's easy to do. It's just, you need to have someone engineer it and you need to remember to do it. Another law that's important for you to understand, if you're an app that allows people to contribute their own user content, so text, videos, art, if you're not one of those apps, you don't need to worry about this. But if you are, there's a law, a federal law called the Digital Millennium Copyright Act, DMCA. What it basically says is that if you're an app platform, if you're a platform that allows people to publish this stuff, the law recognizes that it would be crippling lawsuit liability for you if you, the platform, were sued for copyright infringement every time one of your users decides to upload something that infringes someone else's copyright. So this law was basically written by and for YouTube. So when YouTube first began very, very popular, the problem that YouTube was confronting was they said, you know, because our product is so good, a lot of people are pushing videos to our product, which is great. That's what we want them to do. But what we're starting to see is people are pushing to us videos that rip off someone else's video. They'll give us a video they don't have the rights to use. They'll put it on our platform. And before this federal law was passed, YouTube could be sued for that. Because the argument was they didn't put it there, but they were making money off of seeing it hosted there. And so YouTube went to Congress and said, we need an exemption. We need some sort of way to avoid copyright liability, or else we're going to be shut down. And the solution that was invented by Congress, which is now the law, applies to YouTube and it applies to you if you want to do it, is say all you have to do is put some language in your end user license agreement. It's called a DMCA clause. DMCA is the acronym that usually look the same from agreement to agreement. It basically says if you are a third party, so this is you, the developer, talking to the world. If you are a third party and you think that one of our users has put onto my website or my mobile app something that violates your intellectual property rights, all you need to do is send me a takedown notice. That's the term of art for just an email that says, here's the thing I'm talking about. All you have to do is send me a takedown notice and I'll take it down right away. No questions asked. And that kicks off sort of an appeals process. Then the person who posted it has the right to sort of challenge it. But basically, the way the law stands right now is as long as you allow those third parties to report that stuff, and then this is the key, as long as you jump on it quickly, and you have to respond very quickly, like in a day or two, to take it down. If you do that, you as the platform will not be held liable for copyright liability if that happens. So it's basically a safe harbor for you. But again, the key that people forget is you need to process those inbound requests very, very quickly, which means you need to design a workflow. Typically, you'd want to have a dedicated email account that is just for this purpose, so it doesn't get lost in the email that's sent to some general sort of info@company.com type of email address. So the point is, it's something you can do if this is what you do as an app. All right, just about done here. We can take some questions. This is an example of what DMCA clauses actually look like. I say in the wild, because because the legal issues here is fairly common to a lot of different apps. There's a lot of companies that you wouldn't necessarily think of as content publishers that are actually having these clauses now. So Under Armour. I think of Under Armour as a company that made the shirt that I go jogging in. I don't think of them as an IP, at least copyright powerhouse, but the fact is it still applies to them. So this is a screen grab from their website today. They have a DMCA clause. So basically, this is exactly what I was talking about. If you think that user-generated content infringes on someone's intellectual properties, just let us know, we'll take it down, and then we'll talk to you from there. That's all. So again, Under Armour is doing this because this is a simple way for them to avoid being held liable for copyright issues. Okay, data breach notification laws. We kind of went over this before, but just to recap, separate from your promise to Google and Apple, you're promising them that you will comply with the data breach laws. Now, just reminder that even if you didn't promise this to them, or even if you didn't publish to those platforms, you would still have an obligation imposed by state laws and federal laws to do various things to try to prevent data breaches. and then to report them if they do happen. Key thing to know is these vary enormously by state, so get familiar with your local states. The thing that I highlighted at the bottom is talk to your insurer. You know, it's not an issue if you've got 3 users or a small number of users, but the more users you have, regardless of how your app works, just the higher the likelihood that you're going to have a data breach incident. So you want to buy some insurance coverage at some point. It's surprisingly affordable for basically the value that you get from it. But talk to your insurance company, and you know, it's often sort of one sort of additional supplemental line of coverage that you can get for not a lot of money, and just say, you know, cover me if I have a data breach. The liability for me as a developer can be catastrophic. So I want you to cover me if that does happen. And they'll be happy to sell it to you. Special cases, again, I mentioned earlier, there's a couple of industries in particular where if you're doing anything with healthcare, education, tech, financial services, there's sort of specialized laws that come into play there. So I'll just leave that by saying talk to a lawyer. Yeah. Finally, trademark. Whoops, I lost my place here. Trademark. What I want you to know about trademark is trademark is something you can use as a sword or a shield, so to speak. You can use it as a sword in the sense that if you apply for and receive a federal trademark on either the name of your product, the name of your company, your logo, a particular slogan that you're using, that's the stuff that trademark applies to. You get basically a monopoly on it. If you are the first person, you know, we saw Zynga earlier. Zynga got a trademark because they wanted to say, you know, it doesn't look like anyone's using this name yet. We want to spend a lot of time and money and effort investing in marketing around the name Zynga. So we want to protect that trademark. And now, you know, so they've used it as a sword to prevent other people from, you know, using any marketing assets that use the name Zynga. And it's also sort of a defensive issue for you because you want to do a trademark search really before you spend a lot of time marketing, because you want to make sure that you're not about to go to market and spend a lot of time and money marketing something where you're inadvertently using something that someone else is already using. So that's a defensive aspect of this. So typically you'll talk to a lawyer, say, do a trademark search. I'm dealing with a client right now, actually a software client who are doing a trademark search. He was very excited to use a particular name. He was about to launch some products. These are SaaS products, not mobile, but same difference. So bad news. There is in fact another company that's using something not exactly, you know, it's not exactly yours, but it's so similar to yours that my prediction would be you're not going to want to use that name because you're going to have to rebrand. So he will make the call as to whether he wants to follow that advice. But the point is you want to know the lay of land before you start investing time. Real quickly, insurance coverage, belts and suspenders. Again, the belt earlier, when I'm talking about belts and suspenders, I'm talking about protecting the personal assets of the developer from the liability that happens with all business. One way to do that is to form a corporation or an LLC. The other way to do it, regardless of whether you have a corporation or an LLC, in fact, this is even more important if you don't organize the company, you want to have insurance coverage because this will protect you if something bad happens. If it's a B2C app, you know, direct to consumers, it's a simple mobile game. May not be that important to get insurance. Just, you know, talk to an agent or broker or your lawyer, but may not be that important because who's going to sue you? What are they going to sue you over? It may become more important even for B2C if you have a significant number of users or, you know, specialized issues. Again, you have a healthcare app or something where people could actually encounter some problems in connection with your app. If you have a B2B app, so again, if you're someone who is at a bank or a hospital or something where you're developing in-house or with an agency, an app that people use in connection with business services or healthcare or something like that, then insurance is going to be critical because if something goes wrong with your app or with the data that you get using the app, you know, bad things could really happen. So you want to have insurance to cover that. All right, that's a whirlwind tour. I'll just give a quick closing and then we'll talk about the questions and answers. Feel free to start asking more questions. I see a couple from Martin. I'll take those and any others. Just in closing, hope you find the presentation useful, educational. Obviously, it's high level. Don't think that because you've memorized every word of this presentation, you're not going to have any legal problems because I don't know what you're doing with your particular app. I don't represent you as an attorney. So take it as general advice and discuss more with an attorney of your choice when you get a chance. Again, my email address is there, a9@perkinsthompson.com.